Start. If the submissions of the petitioner are to be believed, they have been deprived of rent for a considerable period of time. Stop. Taking a lock, stock, and barrel view of the present dispute, the aberments and the documents placed before us, we may record a prima facie view, that the respondent tenant has, for the reasons yet undemonstrated, been delaying the payment of rent and slash or other dues, payable to the petitioner applicant landlord. Stop. Para. A tenant continuing in possession after the expiry of the lease may be treated as a tenant at sufferance, which status is a shade higher than that of a mere trespasser, as in the case of a tenant continuing after the expiry of the lease, his original entry was lawful. Stop. But a tenant at sufferance is not a tenant by holding over. Stop. While a tenant at sufferance cannot be forcibly dispossessed, that does not detract from the possession of the erstwhile tenant turning unlawful on the expiry of the lease. Stop. Thus, the appellant, while continuing in possession after the expiry of the lease, became liable to pay masonry profits. Stop. A perusal of the judgments extracted above, as also other cases where Atmaram properties supra, one common factor can be observed, that is, the decree of eviction stands past, and the same having been stayed, gives rise to the question of payment of masonry profit. Stop. As observed above, the respondent contends that since, in the present case, no decree of eviction is passed, and there is no stay awarded, the question of such payment does not arise. Stop. Para. While the above stated position is generally accepted, it is also within the bounds of law, that a tenant who once entered the property in question lawfully, continues in possession after his right to do so stands extinguished, is liable to compensate the landlord for such time period after the right of occupancy expires. Stop. In this regard, we may refer to Indian Oil Corporation Limited versus Jagannath Realty Private Limited. Stop. Since, the appellant and the complainant have married each other, the affirmation of the judgment rendered by the High Court would have the disastrous consequence on the accused appellant being sent to jail, which in turn could put his matrimonial relationship with the complainant in danger. Stop. As a result, the impugned judgment dated 27 June 2023 passed by the High Court and judgment dated 9th April 2021 passed by the trial court are hereby quashed and set aside. Stop.